going to go into complex claims and catastrophic claims, and I want to talk about mock trials here. I'm going to skip ahead a little bit on this because there's only a few points I think I need to make. First, mock trials on the defense side, we do a lot of them in the excess world. We know the plaintiff's bar is doing a ton. They're doing a ton of focus groups. We hear about them, at the mediations. They're doing them for different reasons, but I do think they are testing their cases and they are practicing their claims and getting good feedback. We need to do more and more to even the playing field there. If you're going to spend the money, a few things: pick the right vendor, pick the right setting. Is this one we should do online? Like this is a Magna jury confirm that I did, I think 2 years ago in a case. You can see they have like little Sims avatars. Let me go to the next slide. This is them in the jury rooms. We were able to, listen to them deliberate as if we were in, the hotel other room watching the video feed. And they have buttons where they click green and red if they like it or dislike it. So like I said, you got to know what your cases can spend on, but it's very helpful to do a mock. The other thing I would point out is a lot of times these are done very last minute before a mediation, and they're thrown together, and it's just not a good setting. We come into a case late sometimes, and a mock has already been done, and it doesn't look like there's been any guidance in the mock. You need to start thinking from the initial point, what are the critical issues? Hone those issues and plan ahead for a mock trial with a great vendor so you can really test those issues between the plaintiff and the defendant, putting on arguments specific to test one or two themes or factual disputes, and so you get the feedback you need to plan your case. All right, let's make up a little time here and let's move on to mediations here.
So just a few general tips about mediation to begin with as you go into a mediation. Don't be afraid to invite the bad news with the good. It's important to give even-handed evaluations in advance of the mediation with proper consideration spent on the strength and the weaknesses of the case. So assessing the bad facts and the risk of liability is not a sign of weakness or not being aggressive enough. It's very important before you go into a mediation to do that work. It's also important to have a good relationship between the defense counsel, the claims professional, and the insured, where these things are openly discussed and evaluated. So one thing that we've also found helpful is inviting structure brokers to be available during any mediations. With the interest rates that are available, these are looking more appealing to plaintiffs as a way to spread out the receipt of the payment and make those settlement offers more attractive over the long term.
I'm not going to go over the art of negotiating like I'm a PhD or a former FBI hostage negotiator. I know you've read the books and read the articles. I do want to give a few general observations of what I see that I think is helpful. In terms of liability, instead of expressing in terms of winning and losing, express it in terms of risk. We're all human. The plaintiff's attorneys are human. When they hear winning and losing, they get defensive. When they hear about risk, we're all humans to a certain extent risk adverse. And really what you want them doing in the other room is going to the emotional status of thinking about risk and not the emotional status of being dug in and being defensive. The same is true with damages. We look a lot to data, prior settlements, prior verdicts, similar facts, similar things. Plaintiffs at mediation and the family of plaintiffs are really interested in not the settlement values, but they're interested in what type of money is needed in terms of future monies. So if they have a phony baloney life care plan with 24-hour care and you need to go in there and present to them what they really will need. In these really catastrophic cases, we always advise our life care planners to just provide them what they need, be reasonable, look for other things that they would need in terms of, could you do a one-time evaluation down at the Shepherd Center? Could you add some therapies in there that the plaintiff's life care planner didn't do? Can you add some vacations in there? Can you add something in there to show the plaintiffs that you are really trying to come up with a true plan that they can buy into, or at least compare to the plaintiff's experts' life care plan? Last thing here, the McCammon Group, if you're not familiar with them in Virginia, they are in Virginia and DC and Maryland and a few other states, but in Virginia, they really do have a monopoly. Almost all civil mediations go through them. A few great mediators that everyone in Virginia knows and are the popular mediators between the plaintiffs and defense bar. Judge Thomas Shadrick, who, if you've mediated cases in Virginia, you've probably been in front of him. He's a retired Virginia Beach judge. Judge Brad Stillman, who was a federal judge here in Norfolk. Judge Tom Hoover, who was in New Kent County down in kind of near Williamsburg area. Judge Charles Poston, a retired Norfolk judge, and Justice Jane Rouse, who was a Virginia Supreme Court justice and a Fairfax court judge. And I will say Justice Rouse is still kind of mixing her practice between virtual and in person because she lives out of the state part of the year. So if you're looking for someone who's really into doing the virtual ones, she's been really good at them. Not that all the mediators didn't get good at it during COVID. Okay. Well, we got to the end here. We're 4 minutes over. We're 4 minutes over. We tried to get through it there. We thank you for bearing with us with those internet Zoom issues. It's going to happen. Let me again thank you for coming today. You should have received the written material via email. If you have not, please email us, hit reply all to that email to Michelle Sharon, our marketing director, or email me and Bren, and we will get it to you. We would appreciate any feedback, except for feedback on our Zoom going out twice. We know that wasn't great. But other than that, we'd appreciate any feedback. And I want to reemphasize our involvement with the Themis Advocate Group. If you're ever at conferences, we sometimes, almost every conference, have a cocktail party or an event around. We also do our own events. Really proud that this year the mock trial in June is going to be in Richmond, Virginia. The mock trial by Themis, what we do is we bring in Magna. This is who's the sponsor we use. We bring in a local mock jury, so we pay individuals to come in and sit. They sit on the stage while the Themis attorneys put on a mock trial. We'll bring in a real judge, usually a real expert witness, and then we will excuse the jury into another room. We'll stay with the audience, and we'll watch the live feed of a real jury deliberating. We then welcome the jury back on stage, and we do live question and answer so that you as a claim professional can actually interact with the mock jury. And, we usually do a general liability mixed question, but it's just a great, 4 or 5 hour thing that we do in Richmond. So if you're anywhere near the Richmond area or don't mind jumping on a train and coming down or figuring out how to get there, I'd welcome you to join us. Just shoot me an email and I'll get you the details.